Okay, well, hello everyone. My name is Ben Rhodes. I'm the Senior Vice President with CAMS. Thank you for joining us today. As we're putting these presentations together, we thought with the start of budget season almost upon us, what better way to kick it off with how to put assessments together and what you need to know that your association is properly financed. So we have Chris Gelwicks with us today to help lead us through this discussion. So thank you, Chris, for joining. As a reminder, we do record this session and we do post it on our website at camsmgt.com. So if you have other board members that you'd like to share this information with, we do encourage you to share our website, and it is located on the board members section under webinars. So you can find all of our recordings. There are approximately 27 on our site with all our past webinars. So feel free to browse that and look at many. There's several options for you to see. We will be holding questions till the end, but feel free to use the Q&A option. So if you do have questions, you can find the question and Q&A section down at the bottom of the Zoom feature and type those questions, and we will help ask those questions throughout or at the end of the webinar. So Chris, I will turn it over to you. Let me stop sharing my screen and I will let you share yours.
I will do that right now. Hello, everybody. Again, this is Chris Gelwicks. I'm with the McIntosh Law Firm in Davidson, North Carolina. You know what? I'm going to check that sharing real quick. There we go. Bear with me. I need to move this so that I can see it. So, folks, while I'm getting ready to do this here, the topic is assessments, and the thing that when I first was given that proposal, I kind of balked at it because it's not necessarily a sexy topic, maybe is the way we'd like to say it, but it actually is very important this time of year. You guys getting ready for budget season. We are, hopefully going to look at what our budget is. If we have to do increases, we need to know how to do it. We need to know if we need to vote. We need to know what sort of things we need to include in the assessments. Do we have a special assessment? Do we have a capital improvement coming? So it's those types of things we're going to be talking about today. And so put your questions in. This is probably more of a unique type topic. I haven't discussed this before. So as I indicated, we're going to be talking about board. First thing I'm going to talk about is board duties. And this wasn't something that I led on. I was going to discuss first, but the sum of that one that you'll see is the board has a duty to collect assessments, and he has a duty to collect assessments, all of them, from everybody. And I say that duty, I call it a duty, it's a fiduciary duty, and I'll explain that further when we get there. Then we're going to talk about assessments, increases, and member approval. What sort of things cause or trigger the requirement that members approve an assessment increase. We're going to be discussing special assessments. Again, what are those used for? Why do you need them? Do you need member approval and that process? Further, budget, we're going to talk a little bit about budgeting, and I know Ben Rhodes was in a seminar yesterday discussing budgeting and properly assessing some things to think about when you're setting your assessments for the annual, for the year, the fiscal year coming up. And then everybody asks, well, we need the special assessment, we got to pass it, but how are we going to get the votes? Well, maybe we'll talk some practical things on how to sell it to the membership. So that's our roadmap. First thing I do want to talk about, as I said before, is your fiduciary duty as board members. And I'm going to stress this. The number one duty you have as a board member is to collect money and spend it properly. You are the care holders. You are the holders of the association's funds. Your duty is to ensure that those are kept and spent wisely, fiscally sound. In discussing that, well, let me just say this first too. What I'm going to talk about is going to cover both North and South Carolina associations. So I'm not leaving South Carolina out here. There's some of the statutes that I'll reference later that don't apply to you, but the principles here and really assessing in general is uniform across both states, and you'll see why in a slide or two. But I wanted to just talk briefly about your fiduciary duty. You have the duty to act with as directors in good faith with the care of an ordinary prudent person in the best interest of the corporation. You can rely on your officers, your experts, accountants, lawyers, et cetera, and a committee if the committee merits confidence, meaning you appoint the committee, for example, a finance committee, to do the exploration on how to do assessments in the coming year. You certainly can rely on those individuals to make decisions regarding what your assessments are going to be, what you're going to spend your money on. And I want to highlight the business judgment rule here. The business judgment rule is that if you act in good faith with ordinary care, you rely on your officers, you as a board member are not going to be liable if somebody files a lawsuit saying you made a poor decision. You can make a stupid decision and still be okay. There's case law in both states about that. So if there's a claim that comes in on how money was spent, budgeted, there's whatever decision you make regarding if assessments are going to be increased or whether you're going to levy a special assessment, there will not be 100% everybody going, hey, that's great, let's do it. There's going to be pushback. Why? Because you're spending money and you're collecting money and you're dipping into people's funds and you're dipping into people's pockets to have them pay it. So in that light, you want to make sure that you are acting responsibly, that you're acting with utmost care. And if you do that, even if you make poor decisions regarding these funds, this use of funds, you're going to be protected by that business judgment rule. So let's talk real brief about authority to assess. We're talking annual, special, and the list goes on, and I'll talk about those in more detail as we go. What I have up on the screen here for you is really the main statutes in both states. And none of them, not one of them, describe what your assessment authority is. I get questions even from seasoned managers. Where is the ability to specially assess, for example, in North Carolina in the Planned Community Act? And my response always is it's not there. The only discussion of assessments in North Carolina statutes, in the Condominium Act and in the Planned Community Act, is dealing with budgeting. You have to have a budget meeting. That doesn't really talk about assessments, just talks about how you do your budget. And you can put a lien on for unpaid assessments and foreclose. Again, it doesn't tell you how to assess, doesn't give you the authority to assess, but it just basically says if you assess, you must budget according to certain procedures and you get the ability to lien and foreclose. There is nothing in either state's Nonprofit Corporation Act about assessments, and it wouldn't be. If you recall, those acts deal with how the board and the membership operates their corporation, not so much about, nothing about restrictions and assessments and things like that. The North Carolina Unit Ownership Act basically addresses assessments in one section, and it just says that owners are bound to contribute pro rata towards expenses. Now, for those of you who don't know what the Unit Ownership Act is, it was a precursor to the Condominium Act. It applies to condominiums. And all it says is you're expected to contribute pro rata, whatever that means, towards common expenses. South Carolina has two statutes, an HOA Act that discusses nothing about assessments, only budget increases, and budget increases before they go into effect must be published to the membership, posted, that sort of thing, but nothing about increasing assessments or setting them. And the Horizontal Property Regime Act, which is akin to the Unit Ownership Act in North Carolina, again, allows you to put a lien on for unpaid assessments, but again, no authority whatsoever discussing assessments itself. So what does all that mean? Well, we don't have any statutory authority. That means that assessments are document driven. When I say here, check your documents, your articles of incorporation, your CCRs, or if you have a condominium, your condominium declaration, your master deed, and your bylaws. It is those documents that are going to tell you how to assess, what to assess, It could set the base amount, could give you the authority to specially assess, et cetera. When we're talking about assessments, obviously we have multiple types. We've got annual. Everybody, I think, knows what an annual assessment is. And by the way, when I say assessments, dues, same thing. If I say dues, or if you say dues, I'm going to assume you mean assessments. If I say dues, I mean assessments. You have annual assessments. Now, annual is, you prepare your budget right now for the fiscal year 2023, starting January 1, 2023. You're going to set your annual assessment at a certain level. Now, those annual assessments can be paid monthly, quarterly, or annually, depending upon your setup. But that's the assessment we're talking about when we're talking about annual assessments. Special assessments. Special assessments are normally for things like a capital improvement or repairs to the clubhouse or repairs to the pool, or let's build a play set on the common area. A capital expenditure generally is what special assessments are for. You'll also see things like a special individual assessment. Now, a special individual assessment I've seen in documents that deals with assessments against specific owners. Now, that could be anything. I've seen it reflect something like if you have a townhome community and a single family community together in one, a special individual assessment could be an assessment against townhome owners only for their maintenance costs, for example, if the association maintains the exteriors. A special individual assessment I've also seen language in declarations where if the owner of a property does something that damages common area, the association has the right, pursuant to a special individual assessment, if it's in the documents, to assess the owner the cost of the repair of the common area that was damaged. I've also seen special individual assessments address fines. And I get into the difference here a little bit because statutorily, at least in North Carolina, you have the right to fine whether it's in your declaration or not. And then you'll see miscellaneous, and we'll talk about those in more detail as we go along. The thing about assessments that we always have to make sure, whether you're in North Carolina or South Carolina, is that they are uniform. Uniform does not mean equal. It means the same procedure is used, and they are across the board for whatever type of unit you are. You're uniformly doing it. You are, if you're a condominium association, you are assessed based upon your percentage of ownership. Generally speaking, if you are in a single family or townhome association, it's, you get a single assessment per lot. So the key there, and I cite a case in Ray Johnson, that's a North Carolina case from 2012. The principles apply in South Carolina. In that case, there was a condo association. There were 8 buildings. 7 of the board levied a special assessment to repair 7 of them. The special assessment was levied against the owners of 7 buildings that were going to get repaired, but not the 8th building. Then it came time to repair the 8th building, and they levied a special assessment against the owners of that 8th building only. And that went against the language in the declaration, which required everyone for a special assessment, everyone in the condominium, regardless of the building you're in, had to pay. That's basically what the language said. So, and that addressed the issue of uniformity. Everybody is assessed the same way. And in that situation, they didn't assess everybody the same way. They assessed per building, which was not the setup, which is why that case, in that case, believe it or not, the owners of in building 8 got their building repaired, and they paid little to nothing to do it because everybody else had to contribute in the end, while they did not have to contribute to the repair of the first 7 buildings. So that's the way it worked out. So uniformity in assessment is key. That is how you avoid getting called into court and asking, why are you assessing some people some ways and other people other ways? One thing that I've seen, and I actually had a discussion briefly before we started here, is language that it says something like you can have a maximum annual assessment with the ability to increase it. And when we talk about increases, we're going to talk about that in a little bit. But the wording is critical, and I'm going to table that one and move on to increases, and then I'll come back and talk about it. It has to have some specific wording in there that we'll discuss. So what about assessments? Let's talk about the annual assessments. Can you increase them? Well, yes, of course. You normally, I've not seen anything that says to the contrary in any declaration I've read. The annual assessment is set by the board. There may be a minimum that it starts out at, but it's always set by the board. And normally increases beyond a certain percentage, normally it's 10%, could be higher, could be lower. There may be a requirement of member approval. Some declarations don't have that. Some declarations say board can increase it to whatever they want. So you really have to read your declaration documents very closely. Now I want to go back to the bottom there and talk about the maximum annual assessment. I've seen language that allows, for example, you to increase it to a maximum amount per year, let's say 10% without member approval. And in that, I've also seen that if you do not increase it 10% one year, let's say I increase it 5% this year, next year, if the language is correct, if it's worded correctly, you could increase it the normal 10% that you're allowed to without a vote, and the difference from the year before, which is 5%, as I said. So you could, without a member vote, if it's worded right, increase your assessments 15%. Again, the 10% you're allowed plus the 5% from that was left over from the year before, and you wouldn't need a member vote. I cannot stress enough how critical the wording is, but that is a possibility if you have that language. And if you want to discuss that further for your declaration, certainly contact me and we'll take a look. The thing about these votes with the increase beyond 10% or whatever percentage it is, if you read your assessment section, they will generally have, the purpose for assessments, or the ability to assess will be subsection A, subsection B, here's what they're used for. C, here's we're going to set it. D, if you want to increase it, past 10%, you have to have a vote. And then the next section, when the section after that, generally contain your specific required percentage. Sometimes these percentages to pass an increase could be higher than a majority. And it could have different quorum requirements. I just saw one last week where the quorum requirement to call a meeting to increase assessments past 10% was 60%. Now, if you got 30 people, 60%, okay, so you're in the 20s somewhere. That may not be too hard, but if you got 600 lots, 60% is a daunting task. So, again, document driven, and be very, very cognizant of your percentages and the number of people votes needed or approvals needed to go to increase past your 10% or whatever your percentage is. Now, I want to step into the next issue with that. In North Carolina, we have a set budget process where you have to have a member, the board has to approve the budget, send it to the membership, and then you have what's called a budget ratification meeting, whereby if a majority do not reject the budget is passed. So you basically have a vote if you call it for a vote. South Carolina has no statute like that. And so the budget process in South Carolina, again, is going to be totally driven by your documents. The issue here is that I'm raising is if you have a vote, that you're required to raise assessments past a certain percentage and a budget vote, you will actually, in my opinion, need two votes, one to increase assessments and then one to pass the budget, which could lead to a problem where the budget passes because, at least in North Carolina, a majority do not reject it, but you don't get the required percentage for approval to increase your assessments. That could cause a problem because the result of that is, well, you have a great budget, but you're not going to be able to collect the money via assessments to fulfill that budget. And the result is you're going to have a new budget. South Carolina, depending upon your process, you could have the same problem. Now, you may find a difference of opinion among attorneys about the requirement for one vote or two votes in this situation. It is my opinion that if your documents require a vote to increase percentage of assessments more than 10%, that's an assessment vote, period. It's not a budget vote. And therefore, my opinion is you need a vote for that, and then you'll need a separate vote to pass the budget. Okay, so let's talk about special assessments. These, again, are document driven. I get questions again, this scenario is this come up twice this year already. a board will come to me and say, well, we want to levy a special assessment for this. Can you give us the wording to send to the membership? I say, sure. And I look at the documents and they don't have the ability to levy a special assessment. And I say, you don't have the ability to do that. And they say, well, we did one 2 years ago. Well, that's great. You got away with it, is my response, because the ability to assess, whether it's annual, special, or in any fashion, must be in the document. If it's not there, you can't do it. Now, what if it's, for example, if it's not there, you can't levy one. And then, by the way, if you levy one and you don't have the authority and someone doesn't pay, and then you go try to collect, you know what you have? You have the federal government could potentially come after you and fine you because you've just committed a Fair Debt Collection Practices Act violation for trying to collect the debt that's not valid. So it is very critical. You want to levy a special assessment, you need to find the authority to do so in your documents. And I get the question, if it's not in the declaration, what if it's in the bylaws? Okay, well, what if it's in the Articles of Incorporation? Those of you who may not know this, the Articles of Incorporation are filed on file in the Secretary of State, North Carolina and South Carolina. In South Carolina now, changes to your bylaws are required to be recorded, so that's good. North Carolina, they're not. But what if your restrictions have a section, do not have a section in there about being able to specially assess what your bylaws do? Then what? My response is record your bylaws. At least then there's some authority I can point to that's recorded for everybody to know about, that everybody will be on notice. So I'm going to, if you ask me if you can levy a special assessment, I'm going to first look in your restrictions because that's where your assessment section is normally. There's one difference with that with condominiums sometimes because in condominiums you record the bylaws too. It could be in the bylaws. That's okay because it's recorded as one document. So I'm going to look in the declaration first and then the articles, and then I'm going to look in the bylaws. If I can find it, then I'm probably going to say you can do it, but I would rather see it in the recorded restrictions. How about the purpose for a special assessment? When you look at special assessment language and restrictions, it is generally, you'll see it too for this reason. We're going to fund a capital improvement, or we're going to fund a shortfall in funds. Either is fine. I've not seen too many other reasons other than, and I've seen a few that didn't even have a reason. They just said you can levy a special, or can levy a special assessment. You'll see language like applicable to that year only. In other words, you can levy a special assessment in any assessment year applicable to that year only. What does that mean? Well, there's two modes of thought on that. The first mode of thought is that you must assess it and use it in that year. In other words, assess it and then spend it. Or two, you can levy a special assessment in any assessment year applicable to that year only, meaning you just do it that year and then next year you can do it again. Either way you look at it, the purpose of levying a special assessment is usually to fund something. Whether you have a $500,000 project that you're going to get a loan for and you need to specially assess to pay the down payment, and then you're going to pay the rest of it, or you're going to pay for the whole thing through the special assessment funds. The point of it is that money that you're collecting is going to be levied for a specific particular purpose. And the question then becomes, can you levy a special assessment if the purpose is not listed for a purpose not listed in the covenants? If your covenants say you can only levy a special assessment for a capital improvement, I'm going to tell you that's what you must use it for. Now, are there ways around that? There's an argument that you could levy it and put it in, collect it, put it in reserves because you're funding the capital improvement in 2 years. All right. Well, that's an argument. It's never been litigated that I know of, and that's probably fine as long as you can point to the reason as long as you can connect the money, your project, to something in the restrictions. I'm going to tell you you're probably okay. But the things to think about too when you're levying a special assessment, especially with the purpose that may or may not be listed in covenants, is what are we going to use it for? What is the support level for it in the community? Are we going to be able to defend the levy of this special assessment if challenged? So those are all factors that I consider when I'm asked whether or not an association can levy a special assessment for some purpose that may not be listed in the comments. So those are all things to think about when talking about special assessments. As I indicated, special assessments may require member approval, but they might not. I've seen it both ways. I'm sure many of the managers that are hopefully watching this have seen it both ways too. But if it's required, you got to get it. And if member approval is required, it's going to be in the governing documents. And, you don't want to do that the wrong way, because the last thing you want, and we're going to talk about process a little bit, but you don't want to get the member approval for a special assessment the wrong way, collect the money, and then being told by a court you have to give it back. So special individual assessments. I discussed those earlier briefly, but these are usually for assessed against an owner for expenses incurred due to owner action, fines, etc. These are member focused. I've never seen a special individual assessment needing a member vote to approve it. It's usually just done by the board. Again, this could be anything from owner negligence to fines to simply that this owner, by the position of their lot or the position of their unit, requires extra expenditures that on behalf of the association for whatever reason. I can't think of one right now, but you could everything from maintenance to something like that. In that situation, if you have the correct language in there in your documents, you could specially individually assess that owner only for whatever the costs are. You don't need a member vote. You don't need a hearing. You can just do it. So keep that in mind. Miscellaneous assessments. You'll see them for landscape, water, utilities. Even, and again, the requirement here is uniformity, not equality. There's all kinds of reasons you could have a different assessment in there. I've got one large association right now where they have a page or two of the annual assessments, a short paragraph on special assessments, the ability to specially individually assess, and then they've got all these neighborhood associations, and there's like 10 pages of different types of assessments for those neighborhood associations. Perfectly normal and perfectly allowed, assuming it's written correctly. So, Ben, we're about halfway through, it looks like. Do you want to take any questions or would you like me to keep going?
I'd keep going.
Okay, that's fine. So we talked about the types of assessments. We've talked about briefly how what those are used for. Going back to the fiduciary duty, the board has a duty to properly budget for expenses. And I submit, depending on your association, for example, if you're in a townhome association where the association maintains the exteriors, or if you're in a condominium, my opinion is the board needs to also has a fiduciary duty to budget for proper funding of reserves. Now, I don't know if I'm an outlier on that, but any of you who are on a board of a condo or townhome association, you know that you're going to have to start putting money aside for reserves for roof repair, roof replacement for 15, 20 years. Single family associations, if you've got private roads or a clubhouse, a pool, or even specialized landscape, those types of things you're going to have to consider budgeting for, which means you have to assess not just for what your expected expenditures are for the coming year, but you also have to add to that to fund your reserves. In North Carolina, adopting and amending budgets is a specific enumerated power in 47C and 47F3102. In South Carolina, budget increases must be noticed to the members before they become effective. It's key, it's important. And so whatever you're budgeting, necessarily going to include increasing annual assessments. Now, I'm going to jump ahead to later in the slide deck. No one likes to raise annual assessments. I was on my board for 4 years. I didn't like raising them because it was dipping into my pocket just like everybody else. But in order to compensate, especially nowadays with inflation, the rise in costs of materials, labor, and all of that. I would venture a guess that are probably, of the 121 participants I see, those of you with pools are probably having lifeguard issues and staffing issues and pool attendant issues because you can't get people out there, and your prices have gone up. The COVID has changed or has given us a new perspective on planning for these types of things, and inflation certainly is adding to that. So, but understand, proper budgeting will normally mean that maybe not year to year, but every 2 or 3 years, you're going to have to increase your annual assessments. And you shouldn't be afraid to do that. That's what your job is. And just understand, no matter what you do, whether you increase them, whether you keep them the same, there's always somebody that's going to say, just do everything I want you to do, but don't spend my money. That's what's going to happen. You're always going to have that. So you need to steel yourself for that, because when you're sitting in the seat, and I remember when I was sitting in the seat as a board member, every expenditure on that line item, every proposed one, is there is somebody out there that's going to go item by item and say you're spending too much money or you're assigning too much money to this part of the budget. One last word on budgeting real quick. A budget is simply a projection. It's not a binding, it's certainly not a, hey, I must spend it here. I must spend it like this. It is more of a projection on how you're going to spend the money. And obviously things come up during a fiscal year that you're going to have to spend money on and didn't think of or didn't plan for. That's why it's a budget and not a law. Okay, so we're dealing with increases in special assessments. Everybody says, how are we going to get these things passed? They're not popular, we know that. So what do? We know we're going to need extra funds in the coming year. We've looked at the budget, we've looked at what we want to do. We want to accomplish these things. We have a capital improvement we need to plan for. So the first thing you need to understand, know your procedure. Do we need a meeting? What is the percentage required to approve either the increase in assessments or a special assessment? Okay, got to know that. Prior to, one suggestion I have, prior to levying these assessments, form a committee or committees to look at the options. And I know we get into member participation, and at times that can be lacking, especially if things are going well in the community and no one wants to participate because they got their own lives to lead. But when it comes to spending money, I have found that people are more willing to participate and have a say in how the money is spent. A finance committee allowing non-board members to participate is one option. So prior to proposing the increase, or prior to proposing the special assessment, form a committee and have them come back with findings on what you want to do and what the cost would be. The kicker there is that committee can also, if they get on board with what you want to do, they can go around and get more support for passing the increase or the special assessment. When planning to collect your assessments, an increase, just regular annual assessments, not even an increase, or the increase or a special assessment, you need to be realistic. Not everyone's going to pay. That's the one side. Not everybody's going to respond to the vote or approvals needed to pass the increase or the special assessment. You need to be prepared for that. You need to be able to plan accordingly when you budget, that you may get 80 or 90% of the funds you really need. And so you may have to increase your assessment or increase the special assessment to compensate for those that don't pay. And that's a whole collection process that we get into if you want later. But with regards to getting member participation to approve a special assessment, understand if your increase requires approvals, a non-response is a no. And so it is important that you do what you can to get the word out to the community about what you want to do and why you need the increased funds. And in doing that, provide the necessary detail. The last thing you want is to hear from owners who did not vote in favor of the increase or the special assessment, to say, well, we just didn't have enough detail to make the decision. That's never good. So be clear. Here's the project. We want to put in a pool. We don't have a pool. We want to put a pool in. We took a poll in the neighborhood, and 80% of the neighborhood wants a pool. Okay, so that's why we need the money, and it's going to cost $500,000. That's the cost of the project. Right there, when you say the cost of the project, you're going to have people come out of the woodwork. I give you a prime example of my community. My community has community docks. Those docks had been there for a while. They needed to be repaired, basically replaced. And we had 3 member meetings on the issue. 3 member meetings. I'm going to say it again. I had 3 member meetings on the issue. The expense to redo it, because we had the funds in another fund that was coming in, was going to be minimal. Yet we had 3 meetings on the subject. And in those meetings, people who had never been on the dock in their life were out there describing what they would do to build the structure and do it at the decreased costs. So you need to expect that. And that's okay. They get to participate. That's what the membership is there for. They're the ones in the end that have to approve it. But understand, especially when you're going to try and raise money, you're going to have a lot of people give you their input on how it should be spent and what it should be spent on. Be plain that if you don't get the funds, the project won't be funded. And in a special assessment situation, if you need funds to, for example, to repave a parking lot, the parking lot's got potholes in it. The patching isn't working anymore. If you don't pass a special assessment for $50,000 or $100,000 to get it repaved this year, fine. Then you're going to have to plan. If it doesn't pass, you're going to have to plan for increases in the coming years to put money aside to pay for that project. And that's just the way assessing works. So, as I said, you will always be scrutinized and second guessed by some. The question I get from board members all the time, well, we levy this thing, we're not going to get reelected. Well, your goal is not reelection. Your goal is fiscal responsibility, making sure the common areas and the areas of repair and maintenance that you are responsible for as an association are funded properly. And then the question that I have to ask, because that's why I put it in bold, is why in the world would you want to get reelected anyway? You're getting paid so much money in this volunteer job. It must be it. I'm joking, folks, but the goal is not reelection. The goal is to fund the projects that need funded and to spend the money properly and hopefully to get the money in that you need to pay for it. Cannot stress enough, rely on your experts, your manager, your lawyer, your vendors. Your vendors are key. Prior to levying any special assessment, my recommendation is to go to the vendor and that you want to do it, for example, parking lot repaving, and give him scenarios. Okay, what happens in this situation? What happens in this situation? We need to be able to prepare for these contingencies. Is the price going to go up if we don't sign now, but in 6 months, when we have the money, is the price going to be different? All of those things you're going to need to determine what the amount of your special assessment and or the amount of the increase in your annual assessment. If the increase in special assessment are not approved, obviously you can try again. There's no limit on how many times you can try this. Keep in mind though, especially in the area of a special assessment, if you are wanting to put in a pool, for example, and you want to levy a special assessment for that and you're not getting the support, it may not be that important to your membership. And if it's not that important to your membership, then it shouldn't really be important to the board. I say that we have every board member that, and y'all, this is just an example. Every board member that I've ever talked to says, well, I want to get on the board and do these things. And that's great. That's why it's great for you to serve on the board, because you have goals, you have ideas. But if it's important to you, it doesn't mean it's important to membership. And so it's very important, to not take something personally that doesn't pass. When you're dealing with money, people are going to vote maybe differently than they would on other things. And that's okay. Remember too, and I'm going to stress this is the last part of this slide. If you budget for an increase in if you get an increase in your annual assessments, and you say, we're going to use that increase to put aside into the reserves to fund a parking lot repair. Or you levy a special assessment, and in that levy, that special assessment, the people who approve it based upon the fact that you say you're going to use the money to pave the parking lot, then you better use it to pay the parking lot. Because if you don't, you're going to be attacked, most likely, on what you do with the money. Why didn't you use, like you said, you were going to use? That money was earmarked. Now, circumstances change all the time. And the idea here is, if money is earmarked for a specific purpose and needs to be used for that specific purpose, unless we could document a change in circumstance that makes the use for that specific purpose no longer needed. So, and then that question always comes up then, if we don't use the money, do we have to give it back? No, you put it in reserves. And that would be my recommendation. Once it's levied, it's levied. So, so Ben, we're flying along on these things. I got some questions in the Q&A, so I'm going to finish this up and then we can get into them. Proper funding is essential. You guys as a board, relying on your managers, relying on your accountants, it's your job to make sure that you've got, you're budgeting enough money and that you have assessments set at the proper level to fund and to put in the reserves. And if you are you're going to do capital projects, if you're going to deal with budget shortfalls, it is your job to put the steps in place to make sure those either the areas of shortfall or those projects are properly funded. It's your fiduciary duty. I say budgeting, assessing, and collecting, and good grief, I could do 3 hours on collections, but in my opinion remains the same across all of those. It is your job as a board to collect all of the assessments in the community. Whatever you set them at, you're supposed to collect them. And I won't waver on that opinion. Your power to do this, your power to assess, your power to collect comes from the governing documents. It means you have to know which documents to look at, articles of incorporation. The CCRs are really the main ones, and your bylaws. You have to know the scope of your ability to assess. Do I have the ability to levy a special assessment? Can I specially individually assess an out? Or do I need to call them to a hearing or file a lawsuit? You got to know the scope, and you got to know the procedure for getting these things passed. And in doing that, use your resources. Resources being, again, your manager, your experts, etc. Be clear and transparent with the members. When it comes to money, I'm not saying give them every nickel and dime you're going to spend through the whole year. That would be laborious and really unneeded. But when you are talking about an increase of 10%, of more than 10%, you know, if you pay $1,000 a year, a 10% increase is another $100. That could be a lot of money to somebody. You need to be able to explain why you're doing that. Likewise, with a special assessment, a $5,000 special assessment per house is a lot, especially nowadays. So transparency on what you're going to use the money for, and where the money is being spent when you collect it is going to be key to keeping any insurrection down, keeping any complaints down, and hopefully getting more participation from your members on how these things are on future projects. And in looking at all of this, keep your lawyer on speed dial so you can answer all the questions that you need answer to. So, Ben, that's the scope of my my presentation. Again, this is me. I'm at the McIntosh Law Firm. I do community association law, litigation, corporate law, and I like to play golf, go to the beach, and go to the mountains. So,
well, thank you, Chris. I wanted to make a few comments on a couple of things that you said,
sure.
And I think it's, as you mentioned, it's very normal for associations not to increase their assessments annually. We did do a presentation of probably about 6 months ago. It's top 10 mistakes board members make. And one of those mistakes that we spoke about was not increasing assessments annually to keep up with inflation. And so that is, a real issue this year. And as you mentioned, I did host a session yesterday for CAI North Carolina. That's the Community Association Institute chapter for North Carolina. And we did another similar webinar talking a little bit about budgeting. And one of the things that we talked about was inflation. And we have several vendors that have reached out to us over the last several months saying, hey, we are seeing significant price increases, pool contracts, landscape contracts, insurance contracts. So I want to, before we start the budgeting process for communities around the two states, know that going into this season, you will likely be looking at 20, 30, 40% increases in some of the contracts that you're working with. I read a recent article about in insurance, and property insurance is going up anywhere from 20 to 25%. I was talking with a landscape contract, or a pool contractor just yesterday, and he said, Ben, be prepared for my contracts to increase about 30%. My chlorine cost has almost tripled. My labor cost was $9 an hour average last year. It is now $14 an hour this year. So we're seeing significant increases. So as we go into this, talking about assessments, there will likely, unless you are overfunded, you will likely have to be having these discussions with your membership, during this whole budgeting process. So fun time.
In the discussion with the membership, well, Ben, I know you've experienced this as I have. It's, well, why does this cost so much? Well, why do we need this service? Why do we need that service? And the response is always, well, look, we can cut services, or we can keep the services we have, but pay more for them. And that's the way it is. If you have a landscaper that's charging who now has to charge a surcharge on fuel to get to your property to do it. And if you don't pay the surcharge, he's not going to do the contract. You're going to get the members out to cut the grass themselves, or you're going to hire a vendor. I mean, the choices, unfortunately, are limited. The proper increase of assessments, this actually has started all the way back in the developer stage. And it's unfortunate, and I see this a lot, that developers, when they turn over communities, have not funded, a lot of them have not funded assessments, not funded reserves properly, or they've not increased assessments. And then the first elected board comes in, and they all of a sudden have to do this massive increase just to get the money flowing in so they can pay for stuff. I get it. It's unpopular. But I go back to that fiduciary duty. You're sitting in that board seat. You've got things that you got to pay for every day, every week, every month throughout the year. You got to have the money to do it. And it's your job to go out and raise those assessments accordingly. Not exorbitantly, but if you need a 20% increase because that's how much it's going to cost now, then the members are just going to have to understand that. Scrutiny of how money was spent over the last 2 years probably isn't going to be a very big deal, because the price increasing that we're seeing right now is off the chart. I mean, my fees are going to go up next year. I know that. So, anyway.
Well, so we have about 15 minutes for questions. So I want to get started on questions. And one of the first questions that came in was on reserves. And it's probably not necessarily a question for you, Chris, but it's all about what should I have in reserves? And just that's a weighted question. It's not an easy answer. And I know we talked about reserve studies, or at least in the answer that was provided. We do have a whole webinar on reserve studies and reserve given by a reserve professional. And so would encourage you to look at that webinar for that specific reserve question. But there's not one right answer on how much you should have in reserves. For condominiums, if you want to get certain financing, you have to have a minimum of 10%. So first question, Chris, in South Carolina, how much ahead must the increased budget be posted?
I just looked at that statute today, and I believe it's 48 hours prior to your meeting. I always recommend a week minimum. And it's supposed to be posted prominently somewhere in a centralized location. My advice is mail it out, email it out as well, get it in the hands of everyone. The last thing you want is to pass the budget, and understand, unless your documents require the members to approve it. The statute does not require member approval. Statute requires notice. That's it. So the last thing we want is for someone to try to unhorse the association's budget for the fiscal year because they didn't get the notice out the right way.
Okay.
So the longer, the better.
So you sort of answered this next question, but in South Carolina, can a budget increase be posted in the mailroom, or does the increase need to be sent via email or USPS?
Statutorily, it must be posted in a prominent central location.
Yeah.
I believe, I don't have a statute in front of me, but my opinion is you mail it out to everybody. You get it in the hands of everybody. Post it on the website, send it out in an e-blast, and put it in the mail. And I understand that that's a cost, but again, it stops you then have something reproduced in case someone says, you didn't notice it. Yes, I did. I sent it out 7 days in advance. Here's the postmark.
So when can we use a specific assessment? Can we assess an owner using specific assessment for an exterior repair to just their unit?
All right, so that is a complicated answer, but I will try to make it simple. I believe what you're discussing is a special individual assessment. If the association isn't, say you have a single family association where an owner has let the exterior of his house go into disrepair. The association has the authority in the documents to go onto the property and make the repair. That's the first thing. So in this example, the association has the authority to do it. They go on and make the repair. If it's worded correctly, the special individual assessment would then allow you to assess the cost of that repair incurred by the association to that owner. You wouldn't need a hearing. It's an assessment because you spent common expenses. You spent assessment money to do the repairs that they were supposed to do. Okay. That's an example. Further examples. I've seen fines be listed in special individual assessment language. In North Carolina, that's not needed. And I would further not even call them a special individual assessment. They're a fine. You go through the hearing process and fine them. South Carolina, there is no specific hearing process statutorily. And so in that light, you could, in theory, though I still say give them a hearing, if you have the ability to do so in your documents, you could especially individually assess a fine against an owner who's in violation. I don't recommend that, but that's kind of the situation that we're talking about, these special individual assessments. Anything that the association has to spend with regards to a specific owner that it wouldn't have had to do otherwise would be a special individual assessment that you would be able to use that section to collect from the owner.
Okay. So for individual assessments, you said a vote is not needed. Is this a board vote or a membership vote?
Okay. I'm not sure, friend, that question doesn't really make a lot of sense to me. So let me break it down a little bit. Normally, I've never seen actually a declaration where every year, doesn't matter what the assessment is, it needs approval from the membership. So what I assume you're talking about is an increase. Some documents require a member's approval of if you're going to increase it past a certain percentage, some don't. So if you're going to increase 10% from last year or 12% or 15% and there's no member vote required in your documents, then you don't need a member approval. On the other hand, 5% increase may trigger a member approval vote in your documents. So first step is, yes, the board has to approve first what they're going to do. You have to have a board meeting or unanimous consent via email or whatever, saying this is what we're going to do. We're going to set the assessments at this level. And it's an increase of a certain amount. Then if your documents require, you have to go get a vote. Now, separate from budgeting, you always have to have a budget ratification meeting in North Carolina. In South Carolina, it's really going to depend upon what your documents require. So, but again, your budget has to be passed by the board first. And then if a vote's required in South Carolina, then you have to go through that process. In North Carolina, the budget ratification process.
Okay, I'm going to try this question. Our docs say we can raise the assessment 10% a year. If we don't say what it is going to be, is that the wiser? Is this not a special assessment? Does that make sense?
I think so. So you have the right to raise your assessment level, annual assessment 10% per year. You don't need to specifically say earmark that money for anything specific. Costs have gone up. We're raising it 10% just to cover the basic expenses. That's fine. You don't need to specifically set forth, well, this extra 10% is going to go here, here, here. On the other hand, if you put to the membership, we're going to use this extra 10% to put in reserves to use to pave the parking lot next year, then that money better go into reserves because that's the reason you collected it. I don't advise earmarking annual assessment money like that. You collect your annual assessments to fund the budget for the fiscal year. However that money is spent is how it's spent. Special assessments, usually special assessments are for a specific purpose, for a specific reason. And yeah, that money is going to be earmarked for that unless there's a change in circumstance.
Okay, in South Carolina, is there a source where accurate information can be found about monthly assessment fees or charged by various associations within a specific geographical area? There may be 20 condos within 30-mile radius. How can we as board members find out what other associations charge? And I may take this one, Chris.
Go ahead. I don't want to touch that one.
So I think your management company can absolutely help you. The challenge with this is most of these associations are going to be different. Most of them will provide different services, have different square footage requirements, have different landscaping requirements, may provide water, may provide insurance. So no one association is like the other. And so it can be done, but the information that is being provided isn't always, it's not an apples to apples comparison. So, but I'd say talk with your manager, and they might be able to help you pull some other numbers together for a basic comparison.
Okay.
So you commented earlier, Chris, about the budget is potentially different than the assessment. Shouldn't the base assessment match the annual budget?
Yes, but what I was discussing had to do with getting a vote. If you're going to increase assessments that to a point where you require a member vote, potentially then, depending upon your documents and what state you're in, you could be taking 2 votes. And I believe that's what you're asking about. But your special assessment, you're going to increase your annual assessment by 20%, requires a vote with a quorum of 60% and a majority there. And you don't get those people to attend or vote. You don't get your votes to up the annual assessment, that amount. But you've already passed a budget, and that's up for member vote. And that budget includes the amount of the increase. And it passes. Well, what do you have? You have a budget that you can't fund because the assessment vote did not pass. So that's the situation that I've seen happen a few times. It's unfortunate, and you just have to go back and redo your budget and go from there, or try again to get your assessment passed.
Okay. This one may be a 2-part question. If an HOA makes a special assessment to replace the roof, can each condo owner add that amount to their capital base for future divestiture tax purposes?
I'm not a tax attorney. I'm going to run from that question. I don't know. What I will do is, Ben, I will look into that and shoot you an email. If that owner will provide you his email address to you, I'll see what I can find out.
And then this one is a follow-up to that question. If an HOA makes a special assessment to replace the roof on all buildings, should the assessment be an equal amount for each condo owner, or by the monthly unit owner dues, or a percentage of annual assessment or dues it's based on in the condo?
Okay.
So, is it a flat fee or a percentage-based fee? So
it's all going to depend on how you assess normally. Generally speaking, though there are some exceptions, condominiums are boxes of air. Everybody owns their own box, and then they own a percentage of the common elements, all the rest. So normally, condominium owners are assessed based upon their percentage of ownership of the whole thing. If you own 5% of the condominium, then that's what your assessment is based on. It would be no different for a special assessment. Special assessment would, unless there is something specific in your documents that says special assessments are operated differently, and I've never seen that, then that special assessment, how that is assigned per unit, is the same way you assign your annual assessment per unit, based upon a percentage of ownership. I've seen a couple of documents out there where it's assessed simply by unit, not by percentage of ownership. So 1 unit, 1 assessment. That's rare, but I've seen it. But generally speaking, barring something in the documents, how you annually assess is the same way you specially assess.
Okay. So I know we're just over an hour, and to be respectful of everyone's time and yours, Chris, I want one, are you okay continuing to go? We do have a number of questions that are pending. For those of you that feel the need to leave, we want to thank you for attending, but feel free to stay on and listen to the other questions that are coming in. So, but Chris, I'll go ahead and ask the next.
Sure.
We have a situation that we need to assess a special assessment. We need to fix some garbage stalls, but only certain buildings have these stalls. Should we only assess those buildings, or spread the money out of reserves and then assess all buildings for reserve funding?
Okay. This is really the scenario that I talked about in the Johnson case in 2012. The answer is, how your documents say to do it is how you must do it. If your documents allow for you to only assess the building affected by the common expense that you're going to incur, then you can do it that way. I've not seen documents like that. I've heard of documents like that. Absent some special wording, then you must assess, if you have 20 buildings and you're going to work on 5 of them, you got to assess all 20. Everyone is assessed uniformly the same. Again, it's document driven, but generally speaking, you have to assess everybody for the work, even if their building is not affected by the work. Taking that to your description of pay for it through reserves and then use the capital, use the special assessment to put the money back into reserves. If your documents allow you to do that, that's fine. It's not a problem.
Okay. For known future HOA expenditures, roof replacements in 10 years, do you typically see a charge each year go to the buildup of the roof replacement fund, or a pay-as-you-go approach? So whomever happens to own the condo on the year the roof replaced would have to be paying a special assessment versus a pay-as-you-go. I think that's the question.
I don't know that I've ever seen this, the second approach. You're going to have to replace your roof in 10 years. You're going to start adding, you're increasing your assessments, hopefully before now, and taking some of those and putting them into reserves to go ahead and do that repair when it's needed. So you're assessing everyone over time and putting some of that money in reserves to pay for that repair.
Yeah, and just comment on reserves. I've said this in past webinars, and you'll read about it. Since the Champlain Towers collapse a few years ago, reserve funding, condition assessments, reserve studies have become a very hot topic in the industry. And I would not be surprised if there is some requirements in the very near future that is dictated by the government on requirements around reserve funding and or building assessment studies that are needed. I think probably within the next 2 to 3 years, we will see something like that. So our recommendation is to fund your reserves, get a reserve study, and follow that plan. That's going to be the best thing that you can do as a board member to protect you and show that you're doing your fiduciary duty to the association.
I agree with that. There's going to be legislation. I'm surprised we haven't already seen it come down from Congress. So yeah, it's going to be big. It's going to be likely painful because I would expect a minimum amount of reserve requirement per year, and then all sorts of documentation behind it.
So unrelated to assessments, but how many board members do you have to be legal? At this time, we only have 3, and nobody wants to step up and serve. Lots of apathy in the community. I say you are not alone.
There is, trying to think of the Nonprofit Act, and either one has a minimum requirement. It may be 3. Generally, your bylaws are going to tell you how many directors you're required to have. If you have, you're supposed to have 5 and you only have 3, and the board has appointment power. You can appoint to fill those 2 spots until the next election. If no one wants to step up, then you're going to operate as a board of 3. You have the ability to make decisions. The decisions you make with a board of less than the amount required by your bylaws does not negate action that you take as a board. That said, it certainly could open you guys up to scrutiny, and it would be better if you could fill those spots. That's about really the only way I could say that. There's no, as long as you got one person in place, technically speaking, you can operate. And the failure to, or the inability to fill vacant spots just means that instead of having 5 people decide, you're having 3. If I'm in a homeowners association and I'm a member there and I'm supposed to have a board of 5 and I only have 3, and there's money being spent, I'm going to want to probably investigate why we only have 3 and get involved. At least I hope I would. The fact that you have apathy, probably one of 2 things. Either you have a lot of absentee owners or they're happy with the way things are running. So congratulations.
Yep. I have had a board of 1 before, and it wasn't a board of 1 for long, maybe about 2 months until they were able to appoint people to the remaining terms, but it does happen from time to time.
It can happen, yes.
So we've got a ratification question. So
Okay.
is a vote needed by the membership if you don't have 51% of the membership present to reject the budget that is presented?
No. You want me to elaborate? At a budget ratification meeting, there's multiple steps involved with this. First of all, as long as the board has to, and this is only North Carolina, unless South Carolina documents have the same thing in it. Budget has to be sent out, a summary of it. You got to call the meeting. At that meeting, before a vote occurs, there has to be a call for a vote. There's got to be someone that says, hey, I want to vote on the budget. If no one makes that call, guess what? Budget passed. You can have 100% attendance. Budget passed and no one calls it for a vote. If someone does call for a vote and you don't have 51% of the membership present, there's no reason to vote. Budget's passed. What I generally do is, if we don't have a majority there, I call the meeting to order and say, guess what, folks, your budget's passed, but let's talk about it, because if you want to answer questions, but it's ratified. I don't even worry about discussing the parameters of it as far as a vote, whether a vote's needed or not. You can't take the vote. The vote won't matter because you don't have a majority present.
Yep.
So just to sum up, if I'm at that meeting and you don't have a majority, your question, do you have to call for a vote? No, you stand up. The president stands up and says, we need 51% of the membership to vote it down. We have 38% here. The budget passed, folks. Thanks a lot.
But like you said, that's a great opportunity to explain the budget. And
correct.
An opportunity to communicate to the residents. So
exactly.
Getting off topic a little bit, but a question that we do see from time to time in the South Carolina community: if a homeowner purchased a townhome that has an existing satellite dish, is that new owner responsible for its removal if they are not using it, and any damage that is caused by the dish?
Interesting. Well, satellite dishes are covered by the Over-the-Air Receptive Devices Act of 1996. And the question, what was added to the question is it's not being used. So I guess they've used cable or they're streaming or whatever. They don't need dish anymore. We don't know who put it up. We're assuming it's the prior owner. In a townhome community, unless the documents are written very specifically different than what I've ever seen, the owner owns from the roof to the ground. They own they own it. You just go on and maintain it. At that point, if the owner wants it taken down but doesn't want to pay for it, the association then can take it down if it wants, but it's going to have to foot the bill. The association is the one that's responsible for the exterior maintenance. I'm assuming that's in this case. You know, do you have the ability then to specially individually assess that owner? Perhaps we would really need to unpack it. Ben, have you've seen that question before?
I have. Yeah, whose responsibility it is it, you know, sometimes they want the association to handle it, but it's, you know,
well, I mean,
it happens.
It's the association. The satellite dish is owned by the owner. It's on the owner's property. The association's responsibility is not to maintain the thing. So the question then becomes, if the owner doesn't want it up there anymore or isn't using it, you confirm that. If they won't take it down, can the association? I would say the association can, as long as it's in writing that they're not using it anymore and they want to take it down. Can you then go after the owner for the cost of that? I'd have to read the documents.
Okay. In South Carolina, can you give an example of wording that would allow the association to assess over the 10% annual increase limitation? Our association has not increased assessments in a few years.
Okay, well, that presumes that you can't increase assessments at all, really, is what that question assumes. You can increase assessments without a member vote until the point where the documents require a member vote. So I'm not sure what wording I could give you, and I'd be hesitant to do it anyway without reading the documents, frankly. Wording is so document specific. And maybe I'm not even really understanding the question. Let me just break it down. The 10% example that I gave is simply an example. Okay. I see it a lot. You can't increase assessments past 10% over the previous year without a vote. I see it a lot, but that is an example. It's not, I don't see it in every set of documents. It's not statutory. Some you can increase it without approval as much as you want. Others it's 5%. Some have the consumer price index in there. So I really would need to read your documents to see what you would need to do.
Yeah, we've seen a number of documents that are written with CPI, 3%,
yeah,
occasionally 10%, but the CPI has, you know, been low for a long time, and a lot of communities really struggle to increase over the CPI. If you know,
yeah.
so that is a challenge. Are there any special steps required to return an assessment or a portion of that assessment if it is not used?
Wow, interesting question. In North Carolina, there's a section of the Condo Act and the Planned Community Act which says, reads basically that if you, after you fund reserves and after you take care of all your expenses, if any money left over, you can give back to everybody on a pro rata basis, whatever that means. South Carolina doesn't have that. My question before I would even get into that is, why do you want to return it? If there is never going to be a need for it, if you just don't have anything to maintain, okay, then, you know, procedurally, if it's a special assessment, special assessments are easier than annual assessments to give back, because, you know, if everyone's assessed $500, then, and you're using, you know, you have 100 homes, 500 times 100 is $50,000, and you only use 30, then it's pretty easy. You just refund it back the 20% based upon what the, you know, equal share per lot would be the approach. Annual assessments, it's more complicated. I would just question as to why you would want to return assessments that were already collected that you could put in reserves and save for a later time.
Yeah. So I know if it's for a specific purpose and you don't use it all for that specific purpose, you know, and you're saying it's okay to push it into reserves for future use.
Yeah, I mean, I think there's an argument for that. Obviously, you know, it really depends on how your documents are worded. If it says only for a capital improvement, you can levy a special assessment, you levy it for one, and you don't use it all, yeah, you would then be inclined to return it. Unless circumstances change, and you know, circumstances change where you may need that money for another capital project instead. Would you be required to then go levy another special assessment, return this one, and then go levy another one? That doesn't make a whole lot of sense. There's no real pat answer to that. It's document driven.
And so you could probably put that in your notice saying the purpose of the special assessment is to, you know, complete a project and fund reserves.
Yeah.
Or for future use, something like
That's
that.
true.
So if a budget category falls short, for example, let's say in pool maintenance, can you use reserve money to pay that shortfall? Can you pull from other GL categories, or do you need to do a special assessment to fund that specific GL?
Any one of the three, I think. The preference would be to not pull from other categories because you have that money sort of assigned to that, unless you are at a position in your year where you know you're not going to use it, then you can just pull. It's always better to not dip into reserves for things that are unplanned. I mean, reserves are there for unplanned big expenses. If you have the reserves and you can just pull from that, you can do it. Obviously, depending upon the size of the deficit, you may need to levy a special assessment. It depends on the number. I don't know that your managers would want you to pull from one GL to the other, but you know, the money's all in the same pot. So I guess really the question is, do you pull from the GL first, or do you go to reserves with the understanding that you may replace that money in reserves if something in another GL doesn't get spent? Any one of your options there, I think is acceptable. It's really going to depend on the advice you get from your money people, your manager and your accountant, et cetera.
Okay. The wording in our CC&Rs states the association's board, after a hearing as required under the act, may impose fines against any lot and or suspend. That indicates the board acts not as an individual decision. Is that correct?
Can you read that again?
So the wording in the CC&Rs states the association's board, after a hearing as required under the act, may impose fines against any lot and or suspend. That indicates the board acts as a board, not as an individual decision. Correct. So I think that's saying yes, the board is the board. It's not an individual of one. It's a
yes, yeah,
5 or 7, right?
Correct.
So yeah, so you must hold a hearing to suspend privileges
in North Carolina.
In North Carolina,
generally, yes, unless you have a specific procedure in your documents that says otherwise. And even if you do, I'm going to say hold a hearing anyway.
Okay. Grass is growing in our parking field. We tried to get it repaved 3 years ago, but nothing has happened due to disagreements with the board. I don't believe we can get membership vote on this. Should we just let the grass grow in the parking? I guess it's a parking field, not a parking lot.
You know, now you're dealing with, it's got to be common area, first of all. You wouldn't even be worried about it. And what is the responsibility for the upkeep of the common area? Is it, and the association board has to exercise its best business judgment on what to do. If you can't get I guess my follow-up question to all this is, if you know you need to repave it, or you need to cut it or do something, and you know you needed the money 3 years ago, which is what you said, if you're not going to levy a special assessment, assessments could have been increased to put some money away to go ahead and do it. So what you're doing is by not taking action, you're allowing something that's a common element to fall into disrepair. It is arguably that a member could then come say, well, you're breaching your duty. You're committing what's called an ultra virus act. You're doing something that's unauthorized by the corporation, and you're liable. An ultra virus act, which, I mean, again, it's an action or inaction that is against the corporate structure. It may not be protected by the business judgment. So I'm not saying you wouldn't be, but I would want the board to document its reasoning and probably go to vendors and lawyers and get an opinion as to, okay, our inaction here is justified because of A, B, and C. Anytime you're dealing with a common element that assessments are used to maintain, even if they're not being used to maintain it, I think you're going to have this issue where if you're not going to do the maintenance, you better document it. So I would strongly encourage you to get a legal opinion on that.
Well, and I'll add it, at some point that field may become a liability, and those liabilities, you could be deemed negligent if you are not attempting to correct it. And so it would be wise for the board to show their attempts to get this resolved and maintain, property that is owned by the association. So,
I agree.
Here's an interesting one with a master association. And it looks like it's more of a developer issue, but in our instance, we have multiple HOAs under a master association. The dues to the master foundation is often the greatest expense of the association. Now, we have had variable increases ranging from 0 to 5%. The norm is about 5%. Last year, the increase was 10% and was announced with a little lead time. In the justification, construction of berms, entrances to subdivision under development was prominent. And the covenants, as I understand them, the funds for the maintenance of the entrances, not just the construction. There's never been a vote about the increase of assessments. Should the construction expense be be borne by the developers, and then maintenance included in the budget of the foundation? So I think in this case, this is referencing a large community that is not set up as an association. It is set up as a foundation. And so it may have some different rules associated with that specific community. So I'll let you answer that one.
I tend to agree with you on that. Generally speaking, construction costs are borne by construction of a common area, common element are borne by the developer. The maintenance are borne by the HOA. That's probably as far as I can go with that without knowing more.
Yeah. So if I'm thinking which community this is, it's definitely outside the normal association. I do know associations and say foundations can improve common property, right? That's they have that right. And so they can absolutely spend association money to make improvements on common property.
Right.
So,
that's true.
Can you use reserve funds to pay for a reserve study at the board's discretion?
Unless there's something in the documents that says you can't, I would say yes, you can.
Yeah, and I think that is a fairly common practice. We didn't comment on this earlier, but reserve budgets versus operating budgets and the ratification of both. So that might be a question for next time. But
oh wow, that's a new one. I'll have to ponder that one.
So, but let's see. I don't know if this is a situation, but can a master association level a special assessment on its members' neighborhoods if the member neighborhood isn't allowed to levy a special assessment on its homeowners? In such situation, how would the member neighborhood collect funds to pay the special assessment levied by the master association?
Okay, well, that's going to be the authority to levy any special assessment and who it's levied against is going to be found in the declaration for in this case, the master association, which then begs the question, very interestingly, the master can assess, especially assess the sub or the neighborhoods of the subs The subs can't specially assess their members. How do they pay for it? That's an interesting quandary. And I can't give you an answer to that because whoever wrote those documents did not do the neighborhood associations or the sub associations any favors. It would seem, now understand too, I would want to read the documents to make sure that the master association is properly specially assessing these associations as opposed to the individual members. Generally speaking, most master associations, the membership of the subs are also members of the master. So you're paying an assessment to the sub and an assessment to the master. That said, that's a quandary. That's a problem. I can't, and there's no easy solution to that because I would then look at what the recourse the master has if they don't get paid. So I would need to read the documents.
Yeah, and I have had scenarios like that where the master wants to raise dues or special assess, and then the owners can't come up with those funds immediately due to a vote or something. And so the one option that we had to look at was how much can we raise a regular operating assessment to help cover the increase in master. And so that's, there are maybe ways around it depending on what.
That's putting a Band-Aid on it if it's a big, just a small one if it's a big special assessment.
Right. So, okay, well, that is it. We have answered all of the questions. Thank you, Chris. Thank you, everybody that stayed on. As a reminder, we do post these on our website. The website is camsmgt.com. You can click on the board members resources section, and there will be a drop down, and you will see webinars. So you can see all the different webinars that we have hosted over the last couple of years. Please feel free to look at them all. But Chris, you've held many of them, so I do thank you again.
I'm happy to do it.
All right, we do hold these the third Thursday of every month, and we're working on our next one. It's going to be based on audits and information around tax prep and other things that go into association financials. So again, thank you very much, and we look forward to seeing you next time.
Thanks, everybody.
Okay, bye-bye.